All right, good day, students. Settle down, please. Let's get right into it. Welcome to this Masterclass Explainer. Today, we are tackling a highly scoring, absolutely critical question that is practically guaranteed to appear in your examinations. Question 21, the Constitution and Need of Administrative Tribunals. Now, as law students at KSLU, you have to understand that your evaluator is looking for a rigid, structural approach to your answers. To secure maximum marks for a 16-mark question, you can't just write a sprawling, unorganized essay. You need precision, you need authority, and you absolutely need structure. So let's dive into this explainer and see exactly how to format that winning answer script.
Take down this exact 6-point exam answer synopsis at the very beginning of your booklet, right below the question number. 1. Introduction to Administrative Tribunals. 2. Core constitutional provisions. 3. Framework and tribunal composition. 4. Need and importance. 5. Landmark case laws. And 6. Final exam conclusion. Providing this neat, structured syllabus outline on page 1 instantly captures the evaluator's approval. It tells them, I know exactly where I'm going with my legal argument.
Right. Heading 1. Introduction to Administrative Tribunals. Let's draft that opening paragraph.
On your paper, you are going to write exactly this. Bullet 1, ensure speedy and specialized justice in administrative matters. Bullet 2, introduced to reduce the burden on regular courts. And Bullet 3, designed to improve overall administrative efficiency. Now pay close attention to the phrase speedy and specialized justice. I expect you to literally underline those exact words with your pen. Why? Because it shows the evaluator right there in the very first paragraph that you understand the fundamental constitutional objective. These aren't just alternative courts, they are highly specialized forums designed for speed.
Heading 2. Core constitutional provisions. We are moving to the constitutional bedrock now.
The 42nd Amendment, 1976. Read it, memorize it, write it. When you write 42nd Constitutional Amendment, 1976 in your script, I demand that you double underline this specific year and amendment number. It proves to the examiner that you know exactly when and how these tribunals were actually birthed into Indian constitutional law. Without the Constitution, remember, your answer has absolutely no legs to stand on.
Let us carefully examine the exact comparative text here. Article 323A, Service Matters of Public Servants. Parliament has exclusive power to establish. Now, Article 323B, Other Matters, specifically taxation, land reforms, industrial disputes, and elections. The crucial takeaway here is the strict jurisdictional split. 323A is exclusively for the service matters of those employed by the state, your public servants, and only Parliament can touch this. Meanwhile, 323B is a much broader umbrella. Never ever mix these up in your exam. A confusion between 323A and 323B is a rookie mistake, and it will cost you dearly.
Heading 3, Framework and Tribunal Composition. We've established the Constitution, now let's map out the statutory implementation.
Write this down as your next point. The Administrative Tribunals Act, 1985. Bullet 1. Enacted to implement Article 323A. Bullet 2. Established the Central Administrative Tribunal, or CAT. Bullet 3. Established State Administrative Tribunals known as SATs. Let me explain the methodology behind writing this. By drawing a direct, explicit line from the 42nd Amendment's Article 323A right to the 1985 Act, you're demonstrating a really deep conceptual understanding of constitutional application. You are literally showing how a constitutional mandate becomes a functional, everyday law.
Under that same heading, detail the composition. Step 1, Chairman. Step 2, Judicial members. Step 3, Administrative members. Now, just take a deliberate pause here and think about this hierarchy. Why on earth do we include administrative members alongside judicial ones? Well, it's because blending legal minds with administrative experts is the exact mechanism that creates the specialized justice we highlighted back in the introduction. A regular judge might not know the intricate, technical nuances of civil service rules, but an administrative member absolutely does. This blend is the whole secret to why the tribunal is effective.
Heading 4. Need and Importance. We have now arrived at the substantive core of your answer. This is where you secure the bulk of your marks.
I am going to read through these 6 factors exactly as you must logically reproduce them in your exam. Factor 1, reduction of court burden. Explanation, overburdened regular courts enables speedy disposal. Factor 2, specialized justice. Explanation, deals with technical/service matters via experts. Factor 3, speedy justice. Explanation, less formal procedures, faster resolution. Factor 4, flexibility. Explanation, not bound by strict evidence rules, follow natural justice.
Factor 5, cost-effective. Explanation, cheaper and more accessible than traditional courts. Factor 6, welfare state needs. Explanation, expansion of government requires efficient dispute resolution. Now focus intensely on Factor 4, flexibility. You have to explain to the examiner that tribunals are not choked by the rigid rules of the Indian Evidence Act or the Civil Procedure Code. Instead, they are guided by the principles of natural justice. That means fairness, equity, and good conscience. This is a massive, fundamental distinction from regular courts.
Then, briefly state the importance. Bullet 1. Significantly improves administrative efficiency. Bullet 2. Ensures direct justice to government employees. Bullet 3. Substantially reduces delay in continuous litigation. Summarizing the importance neatly right here acts as the absolute perfect transition before you hit the heavy case laws.
Heading 5. Landmark case laws. Listen carefully, because this section is entirely non-negotiable for passing this paper. First up is SP Sampath Kumar versus Union of India. The issue, the constitutional validity of the Administrative Tribunals Act 1985. On your answer paper, I want you to draw a distinct box around the name SP Sampath Kumar. Make it literally impossible for the evaluator to miss. The background fact you need to explain here is that almost as soon as the 1985 Act was passed, it was aggressively challenged. Litigants were questioning if Parliament could just create these tribunals and totally bypass the traditional courts.
So, read the holding explicitly. Held, initial view, tribunals can be a substitute for high courts, provided they offer an effective alternative mechanism. The Supreme Court initially viewed tribunals as an effective alternative substitute. The court basically said, yes, if the tribunal is just as capable and robust as a high court in dealing with these specific service matters, it can substitute it. You absolutely must stress this historical context in your exam because it perfectly sets the stage for the dramatic reversal that comes next.
And that brings us to L. Chandra Kumar, the Union of India. Notice the tag here, compulsory citation. This is without a doubt the single most critical case law in the entire syllabus for this topic. The issue? The validity of excluding the jurisdiction of high courts over administrative tribunals. The factual background is vital to understand. The legislature, using Articles 323A and 323B, attempted to completely oust, to totally exclude the jurisdiction of the high courts. They essentially wanted the tribunal's word to be absolutely final, bypassing the constitutional courts completely.
Now read this ratio decide forcefully. Judicial review is part of the basic structure. Decisions of tribunals are subject to review by high courts under Articles 226/227. Do you see the absolute relevance here? The Supreme Court struck down those exclusionary clauses. It cemented a rule that no tribunal, no matter how highly specialized, can bypass the constitutional basic structure of high court judicial review. A tribunal is supplemental, it is never supreme. The KSLU evaluator will be specifically hunting for the phrases basic structure and Articles 226/227 under this exact heading. Make sure they find them.
Heading 6. Final exam conclusion. Never end an answer abruptly. You must close your legal argument definitively.
Write this conclusion out verbatim. Bullet 1. Tribunals play a vital role in modern governance. Bullet 2. They provide speedy, specialized, and cost-effective justice. Bullet 3. They complement the judiciary and aid effective administration. By repeating these foundational keywords, speedy, specialized, cost-effective, complement, you safely anchor your entire 16-mark argument. You are gently reminding the examiner that you started with these very concepts, you proved them through the Constitution and the statutes, you tested them rigorously in case law, and you have now logically arrived at a proven conclusion.
As you finish writing that final paragraph, I leave you with this critical thought to ponder. As the welfare state expands, how will the delicate balance between specialized administrative tribunals and traditional high courts continue to evolve? Reflect on this living, breathing nature of Indian constitutional law. Master this structure, cite your authorities clearly just like we discussed, and you will undoubtedly command the marks you deserve. Class dismissed.